Well, thank you so much and welcome to MASA's Masterclass. I'm going to turn it over to our technology leaders who have agreed to present information today on the Minnesota Student Data Privacy Law that was just enacted by the legislature. So with that, I will let them introduce themselves and take it away. Thank you.
Good morning, everyone. I'm Anthony Padrnos. I'm the Executive Director of Technology for Osseo area schools. And you may have seen my name tagged along with my colleagues who are here with me today. And a lot of messages going out this past spring and even early winter when we started engaging with the lobbying efforts and partnership with the legislature around this bill as it was working through the processes in the legislature. I'll turn it over to my fellow colleagues to briefly introduce themselves and we'll get going on the information for today.
Hey, hi, my name is Joel VerDuin. I am the Chief Technology and Information Officer for Anoka-Hennepin School Districts. As I will expand upon in just a moment, I have been a part of these conversations around data privacy and the data privacy bill since 2017.
Good morning, everyone. I'm Eric Simmons. I'm the Director of Technology Services in Chisago Lakes Public Schools, and I've only been engaged for the last about year and a half here as all of this legislation has come to light, and I really appreciate you engaging with all of us here as we've learned about this bill and its impacts to our schools. I'll turn it back over to Joel.
Okay, thank you. I'm going to provide a brief background of this particular bill. There are some components, I think, in the background that are important to understanding some of the intent, and the intent is really helpful to consider when thinking about how do we now react to the idea that we have our bill in place. I'm either getting feedback from me or somebody's mic's open. So I had mentioned just in the introduction that I've been part of this conversation since 2017. In 2017 was the first rendition of a data privacy bill that was introduced. Essentially, it originated, within the Minnesota House, proposed by Eric Osseo as a Republican legislator, and in its origins, in the first rendition of it, it was a bill that would severely limit the exposure of student data out of our student information systems. For those of you that are on the call that know what that is, that's the primary system you use for all of your scheduling and report cards and other things. Eventually that bill over time had made some changes, but there have been parts to it. There's been components of it that have always been a part of the bills as it has changed up until the most recent one, which was passed. And the components of it have always had some level of guaranteed contractual privacy with vendors. In most renditions, there has been a parental choice. And I just went back to the very first one just to remind myself. And essentially it had an opt-in where every family would have to opt in to using, for example, your student information system. For those of us that worked with opt-ins and opt-outs, opt-ins can be much more difficult to manage when you're looking for affirmative choices. And so there's been an element of parent choice in there, and there always has been an element of technology vendor access. What you're going to hear from my colleagues in a moment is that this bill is really kind of broken down into multiple parts. One's going to deal with contractors, one's going to deal with one-to-one devices and sort of the programs that we use to offer computer technology access to our students and what we can do from an education standpoint as employees. So there's going to be those components to it. There was a question in the chat, and we will provide a link to, we'll provide this presentation to you, and then we have a lot of resources which I'm hoping you'll find valuable, and we'll provide those as well at the conclusion of our session. So we hope to have a question and answer. We hope to be able to provide you with quite a few resources to give you a head start in addition to the information that we're going to share with you today. Just want to thank my colleagues and everybody else who's helped arrange this, and other folks who have helped with a part of this bill along the way. And I'm going to turn back over to my colleagues to continue to give you more information about what this bill means and what we can do about it.
So this slide here kind of boils down to what are the kind of three key components that you need to be aware of as a district as we move forward with this law. And as Joel mentioned, it's really broken down into kind of two areas or components. One is really around the data that vendors use and our contracts with our technology vendors. And the second half of the bill is really around kind of one-to-one technology, and it's really hyper-focused on monitoring and surveillance of that technology, and explicitly kind of puts definition around what we can and can't do in terms of monitoring, and what technology companies can and can't do in terms of monitoring. One of the key things to know as this law or bill took different iterations before it came law, is there at one point in time did have a lot of requirements on school districts. And the way that the law is now, this puts the majority of requirements around data privacy and security on the technology companies and the vendors that we work with, as opposed to us as school districts having to maintain some of those components. Some important things to know is there are two requirements that do come back to school districts that we need to be aware of and mindful of, in particular as we're going into next school year, because the law as it's written does put these requirements in place for the start of next school year. And one arena is around notification to families about tools, and the other one is being aware of what we can and can't do with monitoring solutions. So in particular, in the first half of the bill, school districts are required to provide a notice of what digital tools they're using in their system that contains student data within 30 days of the start of the school year annually. And as we continue on, we're going to share kind of what does that mean that in terms of that notification. And we have some resources and templates that you may be able to use with your school district if you don't already have something in place around how to engage this notification requirement. In particular, this notification only applies to tools that you're using for curriculum, testing, or assessment. And within this notification, you have to, let families know here are the tools that we are using in our system for these three areas, and what data they might be using, as well as an opportunity for families should they request to see the contract related to those technology vendors that you have an engagement with. In terms of the second part of the bill, which is really around the monitoring and surveillance components of district issued technology, you have to be particularly aware of appropriate use and inappropriate use of those monitoring tools. And Eric, on the next slide, will kind of dig into some of those components. Essentially, what most school districts are doing right now in terms of monitoring and accessing district provided devices, we can continue to do as we always have. But there hasn't been particular legal language around the potentially inappropriate use of a monitoring tool like there is now within this bill. And then within that monitoring section as well, there's another notification requirement. So if you as a district have one-to-one issued technology and you go in to access in real time what's happening on that device or the geolocation of that device, there is a requirement on school districts, if you're doing that for the purpose of responding to an imminent threat of life or safety. So it's a pretty high bar, but if you're accessing a school issued device for that reason, within 72 hours of accessing that device, you need to notify the family and student that the device was accessed for the purpose of responding to an imminent threat to life or safety. And I'll hand it over to Eric to kind of go into some more details around kind of what practices that we already have in our districts can we continue with in terms of what this law says. And, as I stated earlier, The majority of the requirements within this law are really back on technology vendors. And a lot of the practices and tools that we're using in our system to continue to move instruction forward can continue to happen. We just need to be mindful of what we're doing and making sure that we're kind of communicating around that.
Thank you, Anthony. And I will dive into kind of what this means for current practice. And thank you as well. I know a number of you as participants on this Zoom this morning have really kind of helped unpack what this would mean for your district, or what this might mean for your what's happening within your classrooms throughout the legislative session this year. So thank you as well for just engaging in that. And so there, as we've talked about, there's kind of the provision for technology vendors, and then there's some provisions with requirements for schools. And then there's also a clause that highlights the fact that this legislation does not supersede federal or state laws. And so this law continues to allows for the continued use of tools to meet some federal and state laws. So I have 3 listed here. This is not an exhaustive list, but we feel that the 3 most applicable laws are the Minnesota Safe and Supportive Schools Act, or the Minnesota bullying legislation, which requires school districts to investigate into student conduct online if there are reports or the perception of bullying, even off campus. So the Minnesota Safe and Supportive Schools Act defines what school districts must do to a pretty lengthy definition. The Family Educational Rights and Privacy Act also provides more, it provides parents certain rights with respect to their educational records, their child's educational records. So it really defines like when and where we can share student data. And then finally, the most applicable to allow some of the things for us that we have done previously is the Children's Internet Protection Act. So there are a lot of language in this legislation that talks about requirements on schools, but within the Children's Internet Protection Act, schools are required to adopt and implement an internet safety plan, which includes monitoring internet access to ensure that we keep kids safe, to make sure that access to minors to inappropriate matter on the internet is blocked. It also not just provides, but encourages us to ensure the safety and security of minors within email, within any of our chat tools. And it really just requires us to put an internet safety plan in place to ensure that minors are not accessing harmful material and using the internet for good. And so there are, as you dig through that legislation, it's line 4.29 is where that starts at. But those are some of the provisions within there that really highlight the fact that this law does not supersede any of those federal legislations. And so when we've talked about what does this mean for your current practice, so there are some other federal laws that impact how we need to work with student data, as well as state laws. To start, that opt-out that Joel had mentioned at the very beginning, that was in kind of all previous iterations of this bill, has been removed. I know a lot of you had been a part of engaging with local representatives on that, so thank you as well for that. But another highlight that we would like to share is that through the use and reading the other state and federal laws, screen sharing tools can continue to be used for instruction and technical support. And examples of those are tools like GoGuardian or tools like Apple Classroom. Those are tools that can continue to be used underneath the guise of this law as an instructional or technical support tool. And from there are a couple of other provisions within this. So now that we know really like a general overview of the bill, we did want to dive into sharing some resources around now what do you need to do as a district? Because there are some requirements on you as a district, and one of those is the communication around notifying families within 30 days of the start of the school year. So like both Anthony and Joel mentioned, this comes into play for all of us on this call for this fall. So we need to communicate to families within 30 days of the start of your school year this fall, an inventory of your curriculum assessment tools. And both Joel and Anthony will expand on that a little bit. But specifically in regard to the communication, we put together a resource, and Anthony, I don't know if you're able to open that or if that will drop you into a totally different view. I can link it directly into the chat there.
We'll find out. Are you seeing it?
Yes, thank
Okay.
you. So this is a resource we will share as an open Google Doc, as a kind of a draft message. And so in application, we've unpacked this with a number of different technology leaders around how you would put this notification into play. And so we've talked about, and I think what schools may do is post an inventory to your website. And so this draft communication here could be used for your back to school planning. So this could fulfill the requirement of that 30-day notice, where you would post that inventory to your website. You would link to your website in that communication that goes out to all families, and then also include a contact for any kind of follow-up or additional information on those tools itself. And then we also have the kind of that draft 72-hour notice in there that you could use as well if you are accessing a device for that kind of that strict and limited threat to life or safety. You have to describe the threat and also talk about what features were accessed on the school issued device in that kind of limited scope. And so this is just a draft example that we have put together to share as a resource with you all to really understand, like, what could this look like in practice. And thank you, Anthony, for pulling those up. Again, we will share all of these linked into this slideshow as well. And I will turn it over to Joel here to talk through the inventory.
So maybe to provide a little bit of bridge between what we've already said and including the slide that was just before this, what we provided, and we went through pretty quickly several of the components without really going through line item by line item of the entire bill. What we're trying to focus on is the things that we feel like you're going to have to put in place going forward. And because of some of the timeliness of these, including the notification, for example, that Eric's working, or Eric had just showed you, it's possible that timelines may have already come and passed for things like maybe your student handbook, if that's going out, or other forms of communication that you might be able to tie it to. So based on when this was passed, we're talking to you, but it's quite likely that you may need to put some things in place to get this going sooner rather than later. And so what we're focusing on is sort of the 4 main things that we think we would want to give some advice on how to get and actions going for. But that communication piece of it, please be thinking of any of the other places where you may have school communications going out. You can obviously do a direct emailing. That's a possibility as well, as permitted in there. But for me and in my district, I'm trying to think of the other times when we're talking to parents about things that are different this year. And we have a back to school kind of communication that goes out to all families. So I'm thinking of bundling it in there. The template Eric provided, and we will provide to you as well electronically, has probably something similar to what I'm going to use, just a brief statement about what is the law, and then where they can go to find more information rather than trying to bundle all that information together. On the slide that you're seeing in place here, one component of what Eric shared is we have to be able to respond to people asking for some information about the contracts that we have with curriculum, assessment, and testing vendors. I think some of the questions that we've had so far are related to, well, is this item a curriculum assessment or testing product? An example, Synergy, is a product that we use and has potential for doing a variety of things, including potentially gathering student feedback, and could potentially be used as an assessment tool. We will have to determine as a district whether or not I think that that falls into that category. It's very unlikely that you're going to have somebody tell you all your answers for the decisions that you may need to make when a product may do 90% of one thing but 10% of another. So that's a decision I think that you'll have to think of for yourselves, and to decide whether or not you're making a good faith effort to include the products that do curriculum and assessment and testing. This slide talks a bit about how to go about inventorying those solutions. So particular for me, working in a really big district, this concept scares me because it is entirely possible that with 6,000 employees, that any inventory that I may have of all of our systems may fall a little bit short. So going back to that good faith effort piece, me and my team, and I've already talked to our administrative team here, we will put forth a good faith effort to include the products that we know of, and we'll put that together into a software inventory. So for my purposes, my intent is to collect that information, to provide that in this email via some sort of link to perhaps our website or some other form of additional piece of information where people can find that list of tools that you may have in your system. So if you wouldn't mind, Anthony, clicking, we're providing you with another tool that we think is a good idea. And many school districts are helping contribute to this. And that is a document where if we crowdsource, if we use sort of the crowdsource idea where people are putting these on here, I can see right now I'm looking, and I didn't put my systems on here yet, but there are several systems that we use here as a district. So for example, Seesaw is listed on there. Seesaw is a product that I use. So thankfully through somebody else's work, they've identified the system, the general topic that we use it for, which data elements, which is required within this particular law, and then terms of service, privacy notices. And then if I have a separate contract, I probably would add a separate contract to it. So we're, as we close out with what we're presenting today and we send you information and perhaps any questions and answers, then this information would be available to you. I think maybe if I tried to answer a few questions before they get started, I have a unique situation in which I host my own student information system, which means I'm not contracting with a vendor to host it, which also means that that vendor doesn't have access to the student information. We obviously have somebody who comes in for technical assistance who may work, for example, on queries or database information, but by and large, I don't consider that product to be something that the vendor has access to. So we didn't touch on that going through the specifics of the components in here, but there are, if you have a curriculum assessment or testing system, but the vendor really has no expectation of any level of access to the student data, then you can make a determination that it does or doesn't need to be included within the system. So again, good faith effort, you can make a choice in those kind of things. So again, this would be available to you as a way to begin your software inventories. Anthony's going to talk a little bit about working in a big district as well in terms of how that looks going forward and throughout the school year, what happens when we're onboarding new systems or how you kind of keep track of that internally through communicating with people. So I'll turn it back over to Anthony and hope I haven't been talking on mute this entire time.
Thanks, Joel. And again, the intent behind this resource is, we've been working with many colleagues across the state to kind of crowdsource this with the intent that you could take and make a copy of this and delete out any of the applications that don't apply. So something is already potentially pre-built and could be added to for your unique situation. There are a few questions that I'll jump into here quickly. Sean's got a question in here about, does this apply to iPad apps? And I think the conversation that, I've had with other colleagues around the way the law is written, as well as internally is, thinking about where is that data stored, almost like Joel was sharing with their student information system being housed internally on their own servers. So if you have an application, the way we're understanding it and reading it right now, if you have an app or an application on an individual device where that data is stored just on that device and the vendor is not getting that data back, then that, in my understanding, wouldn't necessarily fall under, kind of the way that this law is written. It's really about data going back to tech companies and being stored at the tech companies themselves. And then we've got, is it possible that some of the vendors collect different data based on a per district basis. Again, yes, that is possible. It's going to depend on what your contract and agreement is with the tool that you may be using, and how you may be using those potential tools as well. You know, thinking about, you know, that inventory process and kind of the requirements around having an inventory and communicating and providing notification to families. One of the other areas that, you know, we discussed, you really need to kind of process through what this means for your system is, you know, what do you now need to communicate to staff around the process of utilizing technology solutions? So if you think in particular, you want to make sure that your employees are aware of the new requirements around tools that can and can't be used and how they're used. So in particular with notification requirements, staff can't just bring in a tool and use it in the classroom without some form of notification to families occurring. And some of those tools, as we talked, might have a monitoring component like Land Schools, or we use Relay Classroom, where every teacher can see what's going on all the screens, and making sure that, you know, your teachers or employees that have access to those tools know that that tool really can only be utilized for instructional purposes or for the uses under federal and state law. So there is, you know, the parameters in there that they can't just go into a monitoring tool whenever for whatever reason to be able to see what's going on a student's screen. And if you are putting in processes like approval processes in order to try and gather that data and collect that inventory, making sure that your employees know of any of those processes that are being established for managing software used, those software approval and adoption processes. And for a district like Osseo, similar to Anoka as a large system, you know, there's a lot of tools that get used within our system. And for us, we've been trying to balance this approach of, you know, where do we want to draw the line of, yes, you can use something, no, you can't use something, versus how we still foster and help promote creativity and innovation in the classroom. And I'm sure many of you are also, you know, wrestling with that and grappling with that. And for many years when technology was coming into the one-to-one environment, it was really a lot of teachers going out and finding new tools, free tools, going to conferences and bringing those resources back and getting very creative in their classroom. And so what I've got shared here in a resource that I'll dig into is kind of the process we're using to try and balance the notification requirements, balance the resources we have to support these tools, and build that awareness with teachers in the classroom of the notification requirement and data privacy. You know, kind of engaging in that capacity as a system while still allowing some space for creativity and innovation. So in this chart that we have here, all of the digital tools that we use in our system get classified in a 3-tier system. This will change a little bit as we're going to a different inventory tool, because we were putting software tools in this as somewhat of an inventory tool. So we'll have some changes to this in the coming year, but the definitions around our classifications are really not going to change. So our, you know, tier 1 classification that we're defining within our system are tools that we are purchasing, we have a contract with, we have a data privacy agreement with, we've vetted for safety and security. And these are the tools that we use in all of our classrooms across the system. So thinking of like Google Workspace for education, our Google Docs, Sheets, Slides, Schoology, Seesaw, our student information system. These are all the tools that all employees, all students are engaging with, and we've got a lot of resources around that to support that. Our tier 2 tools are our level 2 classification. These are tools that are, again, go through a vetting process. There's a data privacy agreement in place with these companies, but they're really brought in at individual school sites or individual department sites for a curricular and instructional need unique to what their department or their school uses. The reason why we have this additional classification is because these are typically brought in and purchased with department budgets or school site budgets, as opposed to part of our larger district budget process. And then really, this is where we dig into our classrooms and have a lot of conversations with our teachers when they go to that conference and they see that really cool tool that they want to bring back into the classroom. These are kind of our tier 3 digital tools. While we encourage tools or teachers to use our district adopted resources, we know that there's some creative and innovative things that might be valuable to kind of test out in the classroom. And as teachers are exploring these different tools, we kind of break these tier 3 classifications into 2 groups. Our category B group, these are tools really like your free online calculator, your free number generator. If you type in timer in Google, you get that little pop-up timer in your Google crossbar that you might use with a class. These are tools that aren't, you don't have an account for students, teachers don't have an account, it's not collecting any data. These are tools that teachers can just use because they're safe, they're not gonna violate anything within this law. Our category A tools, these are the ones where teachers are bringing in a tool free like Class Dojo, or bringing in another free tool that they're linking their student's Google account to, where it might be collecting and gathering some information on that student. In our system, the requirement that teachers need to go through, instead of this long bureaucratic approval process that they have to wait forever and they want to get going with this tool, they need to engage with their principal as the instructional leader and say, hey, I want to use this tool in my classroom, to make sure the principal's aware of it. So if there's any phone calls that come from a family, they know what's happening in the classroom. And then the teacher themselves provide that notification to families to say, hey, we're using this tool and here's why we're using it. And here's a link to the website for this tool and the data privacy agreement that's on that tool's webpage. This is what we're using to kind of balance the requirements around notification, allowing teachers some ability to be innovative and creative, and navigating what this means as the law as we move forward with the new requirements under the data privacy agreement. The other component that, this isn't a requirement within this law, but something that you should be thinking about as well. And I know there was a question about, tech companies having to follow the Minnesota law. There's no requirement on a school district to make sure that the tech company is doing that. The tech companies and vendors are responsible for knowing Minnesota law when they're operating within the state. But I would still highly encourage kind of some best practice around this as you're engaging with technology companies and technology vendors. In particular, as renewal cycles start to come up, is looking at their data privacy agreements within that contract and making sure that they are adhering to the letter of the law. And in particular, when we think about what the technology companies are required to do, they have to make sure that the data is kept secure. They have to make sure that they're not selling that data for any commercial gains or to other organizations that could use that data for anything. And they have to make sure that they have some form of protections around that data. Now, many states have student data privacy laws that have come into effect over the last several years. California is actually one of the most aggressive ones in terms of putting requirements on tech vendors around protections around that data. Minnesota's law is more progressive in the monitoring area, but not as robust in that data protection area. And the resource I have linked here is a general data privacy agreement that in Osseo we've been using for several years. This is modeled after the 23 states that have a more robust data privacy law. And 98% of the time we have tech companies just sign off on this because they're doing it in all the other states they're operating in. But the nice thing about having this data privacy agreement that we use in Osseo is it really defines out what is the role of the tech company, what is the role of the school district, and if there is a data breach, who is responsible for what aspects of reporting on that data breach, and who are the contacts within our organization and at the technology vendors organization should there be any data security issues that need to be progressed through as well. So that's, just encouraging good practice to make sure that you're looking at those privacy agreements. But at the end of the day, it is still the responsibility of the tech companies for complying. And in theory, should a tech company not be in compliance, that's where a family member or a school district could go after the tech company for not engaging in inappropriate aspects of the law. And with that, I'll hand it over to Eric here just to quickly go through this list, even though we've talked about some of them.
Will, and I think before we jump into that list, I did want to highlight that, we've gotten some questions from like tech directors, superintendents, people from all different roles about, will there be some new policy released on this, or will we receive some additional guidance from like MD, for example. And so we hear that there will be, in regard to the school issued device monitoring, or that one-to-one device monitoring, MSBA intends to release an update to their Internet and Acceptable Use Policy 524 summer before the start of the school year, and potentially some other updates as well that we will share out through MASA and any other channels as those come up. And these resources, we call them like crowdsourced resources because we're really looking for some help on that software inventory tool, with the thought that if we all work together, we could tackle what seems like a very daunting task. But I think we've shared just about everything that we have on this list here right now. From the inventory tool, we have a link to these slides. We'll share all of this out. And there's the Osseo's data privacy agreement and the notification template. So I think we have all of that covered. And from here, we are hoping to open this up to kind of a discussion, question and answer session. So if you do have questions, if you could put those into the chat. I think with the number of people on this call, we'll see how questions through the chat go first, and then we'll go from there. So I'll stop there. And I can answer this first one here from Matt about, does sharing this in the handbook annually at the start of the school year meet the communication requirement? I think Joel mentioned a little bit about the intent at the beginning of our slides here. The intent and the language is that we are doing a direct communication. So the language in the bill is that we are directly communicating to families about software inventory and what software we use in our schools. In my opinion, as we've talked through this, a handbook mention is not enough for that direct communication, depending on how you do that in your school district. We plan to just include kind of a blurb with a link to that on our website.
Alyssa, if you'd like to open your mic, we can take your question.
Okay, I appreciate Joel's response. My concern is that teachers sometimes choose tools, and I use Quizlet as an example, where no authentication is needed, but lots of prompting happens. And so from my point of view, if a student will be exposed to prompting, then it doesn't really matter that no authentication is needed. I wouldn't classify that as no authentication needed, right? So I guess then we're talking about parental approval, but I think there's also a difference between giving, like, I'm a teacher, I've chosen this tool, I ask students to log into this tool, but it's basically a walled garden. There's a difference between that and I'm a teacher, I've chosen this tool, the student is repeatedly prompted to log into Facebook or other social media platforms where there is no walled garden, and so then they are basically agreeing to have their data be scraped by that social media platform. And so if we can't control whether or not students see those prompts, then it seems like we're talking about two different classifications of tools. But
Yeah.
I know I need to look at your classification system in a lot more detail to understand where we would classify that, and also that every district needs to make its own decisions about that. But I guess my concern is that teachers respond so frequently to something that's promoted as free, and don't think about what it means if a student voluntarily gives their social media account information.
Yeah, that's the great question I think we're all wrestling with and are going to continue to wrestle with on how we navigate this with teachers. And, you know, as I was sharing that tool, it's trying to figure out that balance of, do we go the hard line and say, no, you can't use this, or try and create some space of opportunity for flexibility with teachers in the classroom? And it's created some good dialogue and engagement around exactly what you're saying of, you know, are students prompted? Do they create an account? You know, I would say even if they're in a walled garden, if it's connected to an account that data is collected on them, the bill isn't going to care whether it's free and scraped or whether it's in a walled garden. There's an account with data associated with the student in the vendor's hands. They're still going to be required for parental notification. And we're trying to balance out this, okay, here's what we're going to notify on at the beginning of the school year of the 100 or so tools that we know have gone through a vetting process. We know what the data privacy agreement is, versus the additional 150 some that are probably in the classroom as free tools that teachers are bringing in, to help balance tracking through that and creating an inventory. Good question though. And good challenges that we're going to have to wrestle with within our systems, and how we're using these and what's happening with them. And Rob, I don't know if that addressed some of your question as well, but a difference between sanctioned tools versus something rogue that a teacher is using. Again, you know, the notification requirement, it doesn't care whether it's formal district adopted or teacher is using that in the classroom. If it's being used in the educational setting and data is being collected, there's a requirement around notification. So that's where, as a system, you're going to have to grapple with, are you going to allow teachers to continue to have some level of flexibility, and how are you going to address that notification requirement around there? Or are you going to take more of a hard and fast line as a system and say, you know, these are the only things you can use, and what that means?
I do see another question from like Tom Marble on there about, is there a specific list of data elements that will trigger a notification to parents? I don't know if, or were you thinking like the classroom level tools or the district level tools? Like at the district level, it's really just defined in the legislation as like our curriculum assessment and instructional tools is really all it's defined, at least on at the district level as it relates to this legislation.
I had also included reference to the line that the definitions, there are definitions of exactly what educational data is within the bill. And then it may track back to some of the other laws around educational data, but it's mostly anything personal that you keep on a student.
And Joel, maybe just to explain that for everyone else, like there was some discussion as this was being developed, that like, or discussion and concern from other legislators that this would kind of redefine what educational data was, and this doesn't go through and kind of redefine that. They just reference back to a number of other previous laws.
I see a question in there on, did we say the handbook mention is not enough? No, a handbook would be enough. The requirement is just an annual notification at the beginning of the year. I look at it very similar to those of you who might have a e-learning plan in place for inclement weather. There's a notification. It's a very similar notification requirement as in that legislation, where before the school year starts, families need to be notified that you have a plan, or in this case that you that you're using this group of tools, and here's how you can find out what group of tools you're potentially using in our system. So, again, in Osseo, we're looking at our back to school messaging that we send on an annual basis to all families. We aren't going to put the whole inventory list in there. We're going to steer them to our website where we're going to have that publicly posted, and just notifying families that, hey, we use a variety of digital educational tools every year for curriculum and assessment and so forth. And should you want to know more, here's where you can go to learn what tools are being used and how they're being used.
I do set a question around kind of the timing, the 30 days. I don't know that we'd answer that. The language just says within 30 days of the start of the school year. So we're interpreting that could be before, could be after. And we've all kind of mentioned like a back to school type communication, which would be before school starts, but it's just written within 30 days of the start of the school year.
I saw a question there about the digital resource standards. Yes, that document will be included as an example for you to take a look at.
And Brett, not to expand on there, I'm reading your question about like 30 days. Does that mean school days? Does that mean calendar days? It's a really good question. It's just written within 30 days of the start of the school year. So I think they're intent is probably calendar days.
Rob, I see your question on Ken. We add tools to the list during the school year. Again, the way we're interpreting this law right now, we can only provide the list of what we know within that 30-day window. The inventory tool we're going to use, we're just going to continue to add to it throughout the school year. So, the notification piece that will come within the 30-day window, and that inventory list will continue to change throughout the school year as new tools may get added.
I think there continues to be questions about the handbook. It might be possible that different districts handled their handbook differently. And again, I think I would rely on the concept of, are you making a good faith effort in communicating with families? If you know that your handbook doesn't reach a bunch of families, that may be something to think about. But if you have a sense that however you deliver that handbook, that it reaches the families, you might be able to consider that you're making a good faith effort to do that. Electronic or direct communications, there's those methods, both are available, at least within the language of the legislation.
And I know we have some special education staff in here, and I know there's a lot of conversation in MACE on previous iterations of this, because when they originally had the opt-out in there, families could technically have opted out of something like SPED forms. The way again, we mentioned this earlier, but the way the bill is written, there's no opt-out. So SPED forms and student information systems, families can't choose to opt out of those systems or platforms. So you can continue to use those without the fear of individuals opting out. So you can still manage through the paperwork and caseloads around that. And again, in terms of whether you need to notify on that or not, there's the narrow definition of curriculum, assessment, or testing tools. And if you're not really using SPED forms as a curriculum tool or conducting or doing assessments on students, and it's more just kind of the warehouse for special education management, then presumably as a district, you might not even classify that as a tool that needs to be notified or inventoried on. So again, those are some of the conversations you'll have to have within your system on how you classify, what those tools are within that scope. But SPED forms is good to continue to use. I see a question in here on data privacy agreements with free software. It depends on the company. It tends to be a little more difficult with free software tools or a tool that is free but has a paid version, because they'll often push back and say, we're not going to enter into this unless you're going to pay for our paid version. We've had some challenges in Osseo as well when we're vetting a tool and it's not a large enough quantity of licensing within that tool. They might not want to agree to our data privacy agreement. And typically when that occurs, we'll kind of get into a conversation twofold, either one, what other alternatives might be out there to use instead, or we'll put it in our classification 3, where we'll still notify families that, hey, here's the tool that's being used in a classroom, here's the privacy policy. And for us, this isn't a requirement for you, because there's no opt-out provision, but in Osseo for those tier 3 tools, because they're not our core standard tools, families do have the opportunity to say, hey, I don't want my student to participate in that tool. But again, that would be for you as a system to kind of engage with and understand how you want to potentially tackle that. In terms of using the tool for them being free, if they wouldn't sign a data privacy agreement, you still could, as long as you're notifying parents and you're, providing them with the opportunity to be able to see what that data privacy practice is that company has. And there is no opt-out. So if you define that as a core tool, you could still continue to use that as well.
For Brian's question about reaching out to anybody during the summer and for anyone else, I know I'll answer for myself that I'd be available and interested in answering questions if people do have that. I see Eric and Anthony nodding as well. So you'll have our names and some contact information for us when you receive the presentation.
Rob, on the question on data destruction, in the law, there is a requirement that they do have to destroy that data at the end of use by, that's default in the Minnesota law. So in theory, should a company not destroy that data at the end of the contract and you find out, it would be grounds for you or a parent guardian to actually go after that company in violation of the state law. Another question in on the notification component. There is nothing in the law that says we need to provide added notification throughout the year. It's just the annual notification of kind of we use tools and where to find those tools and that information. I would suspect in theory, you don't necessarily need to continue to notify throughout the year every time you update that list. Because the requirement, as the language says, is just at the beginning of the school year.
maybe this is an opportunity for anybody who didn't type in a question in the chat, if you want to maybe unmute or raise your hand.
Rob, that would be correct. So the law says that they have to destroy the data, whether or not you have a data privacy agreement with them. That data privacy agreement is not required under the law. That's, a practice that, we use in Osseo, and I know many other school districts in the state have some version of a data privacy agreement they've been working with over the last several years.
Well, looks like our questions in the chat here have dried up. Thank you to everybody here for engaging either live with us today or catching the recording of this later that MASA will be sharing out. But we definitely appreciate the opportunity to engage and just talk about our new student data privacy law. And again, we'll follow up with the resources that we've mentioned numerous times. And just appreciate you all working with us. Thank you.
Thank you, everyone. And just echoing again what Joel said, as you're processing through this summer, definitely feel free to reach out to me, Joel, or Eric. We're happy to engage in dialogue. We're by no means the experts. We've been engaged in this a lot and helped try to coordinate a lot of conversation with colleagues across the state. So we're happy to bounce ideas off, or attorneys. I know Tim Palmatier, our general counsel, is on here today, and he and I have had a lot of conversations over the year around the language of this bill. So thank you, everyone.